Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examinations. Before we start with our today's analysis, we have two gentle reminders. The first is with respect to the magazine. In case you are looking for a magazine which will cover most of the issues comprehensively for your KAS exams, CTI, Group C, PDO, FDA and other state exams, what we are producing you is some of the best content that can possibly cover all angles that are required for these examinations. So the first issue, which will cover topics from November 2022 up until April 2023, is already in the market. The second edition will be released in the month of December 2023. The second announcement is with respect to the test series. For the test series, what you have to do is subscribe to the test series. We have already conducted one test series on 18/10/2023. Followed by this, we will have the All India GS test series for CTA and Group C exams, All Karnataka Communication Paper test series for CTA and Group C exams, which will be held on 22nd/10/2023 at 10 AM as well as at 2 PM. And we will also have the weekly current affairs test series on 25th/10/2023 at 10 AM. Let's get started and look into the first article. The first article here is speaking about special and local laws. First, we have to understand what are these special and local laws. Then we will understand what is the context to this. We will look at data and we will also look at arguments which says that as much as reformation and system changes that we are bringing in the main procedural as well as substantive law on the criminal front, we also have to bring changes to the special and the local laws. This is what this article is in brief gist. So what is the special and local laws? When it comes to the criminal justice system in the country, what we have is two kind of laws. One happens to be what is called as the substantive law. The other is what is called as the procedural law. What is the substantive law? If we speak about general substantive law, we have the Indian Penal Code. The Indian Penal Code happens to be a substantive law. What do we understand by substantive law? Let's say, for example, a person has conducted an illegal activity. For example, a person has involved himself in theft, or a person has committed a rape, or a person has committed a murder, or a person is involved in dacoity whatsoever, or criminal intimidation under section 506 of the Indian Penal Code. Where are these laws present? These are present in the Indian Penal Code. So what happens in the substantive law? For a particular crime or an illegal act committed by an individual, what will be the imprisonment terms? That is defined under the Indian Penal Code. So what is a murder? What is theft? And if a person engages in an illegal activity or theft, what will be the penal provision imposed on this person is present in the substantive law. So the substantive law basically gives you an idea about what that particular crime or an illegal act is, and subsequently it also gives the punishment or the penal provision that is present under the Indian Penal Code, which happens to be a substantive law. Then we have something called as the procedural law. What is this procedural law? We have what is called as the CRPC. The CRPC is the Code of the Criminal Procedure or the Criminal Procedure Code. What happens in this particular case? Now let's say a person has to be arrested. So if a person who has conducted an illegal activity or he is actually involved in a cognizable offense, what is the procedure that the police officers will have to follow is given in the Criminal Procedure Code. Let's say, for example, since I am an advocate, I also bring to you the practical reality of things. Let's say, for example, when it comes to the Criminal Procedure Code, we have something called as the EP application. What is this EP application? This is called as the exemption petition. What is this exemption petition? Under which section it is filed? It is filed under section 317 of the CRPC. What exactly happens? Let's say, for example, there is summons issued to an accused, and the accused in a specific situation is not able to come before the court of law. So I go before the court of law, I give an application under section 317 of the CRPC. I request the honorable judge saying that, dear judge, this person is not able to make it up to the court of law, so kindly exempt him, give him a permission not to appear because he has some exigency, he has an urgency, he has health related issues, he is not in the city. So I file an application before the honorable court, and that is what is called as procedural side. So if a person has to be arrested, what are the procedures that have to be followed by the police officers? Or let's say for example I have to file a bail application, what are the procedures that I have to follow in case I have to file a bail application before the honorable court? So these are the procedures that are prescribed in the CRPC. So what happens? We have the substantive law, we also have the procedural law. When we look into the present situation, what we currently have is the new form of laws in the form of Bharatiya Nyaya Sanhita. So the Bharatiya Nyaya Sanhita, or every other law that the government of India is planning to bring reforms to the criminal justice system. We have the IPC, we have the CRPC, we have the Evidence Act. These are the major foundational layers of the criminal justice system. So what the government is planning to come up with is bring changes to the criminal justice system. So they have introduced new bills as well. So in the present situation, the author goes on to say, since we are revamping, reforming, bringing a change in these laws, why not bring a change to the special laws as well as the local laws? That is the context. Since we are planning to change the criminal justice system foundational laws, why not bring a change to the special laws and the local laws that are in existence, is what is this article about. So the question is, what are these special laws? What are these local laws? Let me explain with the help of an example. So for example, we have the Indian Penal Code. The Indian Penal Code, which happens to be a substantive law, is one such law which is called as a general law. In general law, most of the important aspects when it comes to the criminal jurisprudence are covered. But what if there is a specific issue which is not covered under the general law? So to address these special and specific issues that are in reference, that is what is called as the special laws. So in special laws, what we have is, let's say for example, we have drug related cases, or for example, we have some person who is involved in the narco terrorism, so require a law which is not present in the Indian Penal Code. So what does the Indian government do? It immediately introduces NDPS Act. And for example, the women of late are also the people who face the atrocities as well. So what should happen? See, Dowry Prohibition Act comes into the picture, or there is specific society, there is a specific community within the fold of the society who are treated abysmally historically. So in order to safeguard their rights, what we have is the SC/ST Prevention of Atrocities Act of 1989. So these are the special laws. So if we have to take the example, what we have is the IPC crimes, which are very specific and general in law. So we have crimes against public order, riots and arson, crimes against property, economic crimes, crimes against women, we have crimes against children. These are the general laws that we have. But when it comes to the special laws, what we have is some of the laws, like for example the Dowry Prohibition Act, Narcotic Drugs and Psychotropic Substances Act, or we also have Indecent Representation of Women Prohibition Act of 1986. And these are the special laws which have specific focus. They have a specific subject matter onto which they are focusing. In case there is a subject matter which is specific and special, and in case there is a general law, the precedence is given to the special law and the specific law when it comes to the criminal jurisprudence. So in case there is a conflict between the general law and a special law, the special law will be given importance to. Added to that, we have something called as the local laws. What are these local laws? When it comes to Indian federalism, we have the union list, we have the state list, and we also have the concurrent list. When it comes to the state list matters, state would be able to make the laws, and even when it comes to concurrent matters, they would also be able to make the laws as well. So what if the state governments have come up with a law which has a specific orientation to a specific region, and a region which is under the control of the state government? So all those laws which have been made by the state government, which are specific focus to that local entity, that local region within the boundaries of the state, that is what is called as the local laws. So what are we focusing on? We are focusing on special and the local laws. So the general law happens to be the Indian Penal Code, but then we have the special laws which are specific laws which are specific to a subject matter, and they become the special laws. And then what we have is the local laws which are created by the state state governments. These are the creations of the state governments so that it is applicable only to that specific region. If we have to take the statistics into picture to illustrate, nearly 39.9% of all cognizable offences registered in 2021 were under the special laws and the local laws. As per the crime in Indian statistics of 2021, of the total of 61 lakh cognizable offences registered, 24.3 lakh offences were registered under the SLLS alone. On the qualitative side, SLLS have given rise to several fundamental and pertinent debates, discourses and discussions regarding the limits on the state's power of criminalization, especially in the context of violation of individual rights and liberties. So this clearly gives us a picture. As much as we have the grounds that are covered under the Indian Penal Code, crimes that are covered under the Indian Penal Code, we do have special and local laws where large number of cases are also filed with respect to these laws as well. For example, it can be with respect to the Enforcement Directorate, it can be with respect to the PMLA as well, it can be with respect to the NDPS Act, it can be with respect to the Dowry Prohibition Act, it can be with respect to the POXO Act as well. So these are the special laws that are in picture. So as much as cases are getting registered under the Indian Penal Code, in comparison, we also have special laws under which police have also been filing cases as well. Now the author says, since we are bringing a revamp, reformation and a change in the general laws, why not bring a change even with respect to the special and the local laws? That is because the author goes on to say that there is a large scale ambiguity and at the same time grey area, which is why we have to address the special laws as well. The author brings into picture the Unlawful Activities Prevention Act of 1967, which happens to be called as UAPA, which is a special law. And similarly at the state level, we also have the Maharashtra Control of Organized Crime Act of 1999, which is specific for the state of Maharashtra, and this happens to be a local law. So the author takes into picture one the special law, the other happens to be the local law. Taking these two laws into picture, the author goes on to say that there are some definitions within these laws. Whenever you look into any of the laws for that matter, what you will have is a preamble followed by what is called as the applicability or the jurisdiction under section 1 of that particular act, and followed by this you will also have a definition in section 2 or 3 of that particular act. So under the definitions of UAPA as well as MCOCA, what we have is terrorist act, which is defined, unlawful activity, which is defined, organized crime, which is defined, organized crime syndicate, which is defined. But these definitions and statements that are made in these special and local laws, according to the author, he says they are ambiguous. They give rise to multiple interpretations for the same definition as well, and at the same time these definitions are also vague, since they create new doubts in the picture every now and then. These special laws and local laws will also have to be changed and introspected. Since we are bringing a change in the IPC, CRPC and Evidence Act, why not bring a change with respect to these special and the local laws? Because they are vague. Why? Because their definitions are not proper. So why not have a relook, recheck and reintrospect into this particular area, says the author. Then we have the Protection of the Children from Sexual Offences Act. Of late, there has been one of the debates that has been undertaking when it comes to the POXO Act. What happens in the POXO Act? Let's say, for example, we have a concept called a statutory rape. What is a statutory rape? Anyone who is less than 18 years of age, in case they give consent, that they say let's have a physical intimate relationship, that is not accepted as a consent because they are not in the right state of mind to give the consent. And as a result, even if they have given the consent, even if they are less than 18 years of age, if they have given the consent that let's engage in a sexual activity, that consent is not taken by law, and that is what is called a statutory rape. So in general, rape happens when consent is not given, but in statutory rape, consent is given, but they are not given the power to give the consent, and as a result they come under what is called a statutory rape, and this is under the provisions of the POXO Act. So there is an introspection of late that children, or let's say for example young adults who are between the age group of 16 to 18 years of age, they are in the process of exploring their body. They engage in a romantic relationship. The girl might have given consent to the boy and the boy might have engaged in the the physical activity with the girl, but since this comes under the statutory law, that is a statutory rape, this person is booked for the charges of POCSO, and ultimately this person's life and even the reputation could be at stake. And as a result, there are Romeo and Juliet laws, which means that in case if it is statutory rape and the consent has been given by a girl to a boy whose age difference is not more than 5 years, an exception has to be given that it is not assumed as rape, but it is a romantic relationship. The discussion is on. We have the Chief Justice of India who had recommended the government to look into it. We also have the Madras High Court, Delhi High Court look into it as well. But we also have the Law Commission of India, which recently gave a feedback as well. The Law Commission of India said that if it is in the form of law, there are people who can misuse this loophole. So instead of coming up with the law, this discretion has to be given to the court officers, that is the judges, and they decide whether that particular person has engaged in a statutory rape or it is a romantic relationship. So the Law Commission had also said that in such cases, what we have to do is that power should be given to the judiciary to decide. This is about the POCSO Act, and similarly there are many other laws. For example, the Negotiable Instruments Act, where there are check bounce cases. In all these check bounce cases, though they are civil in nature, they are given the color or the tinge of the criminal antecedents. So the Supreme Court in the case of P. Mohan Raj versus MS Shah Brothers Inspat Limited referred to section 138 of the Negotiable Instruments Act as a civil sheep in a criminal wolf's clothing. So all this leads to a presumption and an assumption and a change that we have to bring when it comes to the special and the local laws. Why? Because there are large sections which are increasing of late, which is giving to a lot of ambiguity and grey area. So let's bring a change, says the author. Then there is increasing powers of search and seizure under section 43 of the UAPA, admissibility of the confessions recorded by the police officers under section 18 of the MCOCA are prime examples. The stringent provisions provided for under section 43D5 of UAPA, section 37 of the Narcotics, Drugs and Psychotropic Substances Act, section 45 of the Prevention of the Money Laundering Act make the grant of bail a near impossibility. So we have to change these as well. And the increasing enactment and application of SLLS represent an understanding of criminal law which is out of sync with the original project of codification. Then the author says in the year 1860 we had the Indian Penal Code which came into picture. So originally it was envisaged as the only law which primarily looked into the substantive part of the criminal laws. But then the author says since we have evolved over a period of time, we have more special laws. These special laws, if need be, should be taken as a separate chapter into the Indian Penal Code. So in case we are reforming the Indian Penal Code, we are coming up with Bharatiya Nyaya Samhita, so a replacement is called for. So if there is a specific law, this specific law or the special law can be added into the Indian Penal Code or the Bharatiya Nyaya Samhita, basically to add as a different chapter rather than as a different law in itself. And these separate chapters within the larger structure of the Penal Code will help, and separate procedure for reporting of offences, arrest, investigation, prosecution, trial, evidence and bail can also be added in the CRPC. That is, a change will be brought into the CRPC. Such should also be added together, says the author. Since the special and local laws have their own understanding of the law, these will have to be introspected, added as a separate chapter in the Bharatiya Nyaya Samhita and in the procedural code that we are coming up with this, says the author. So basically the author goes on to say, if we are planning to change the overall foundational laws of the criminal jurisprudence, these changes will also have to be introduced, says the author. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says, why are earthquakes frequent in Afghanistan? This article here is speaking about there are increasing cases of earthquakes that we are witnessing in the country of Afghanistan. Why is it so? Let's look into the data. An earthquake of magnitude 6.3 struck western Afghanistan barely a few days after multiple earthquakes of similar strength killed at least 1,000 people in the Herat province. So the first important parameter from the preliminary examination point of view, Herat was recently in news. Herat is part of which country? Is it Iran? Is it Indonesia? Is it Palestine? Is it Saudi Arabia? Which is the country that Herat province is present in? So the answer to this would be Afghanistan. So remember, the first point of introspection and from the preliminary examination point of view is, where is Herat province? It is in Afghanistan. Multiple earthquakes have destroyed entire villages in the country. Afghanistan's Taliban run government are also not able to give the precise numbers because their data is not to be trusted, similar to what the Chinese give when it comes to the COVID-19. Since Chinese come under the communist ideology, their numbers cannot be trusted. Similarly, the Taliban's numbers can also not be trusted, but the UN's humanitarian office had earlier said that there are as many as 1,300 people who have been reported dead according to this earthquake in Afghanistan. Afghanistan is not the first time that it is facing such earthquakes. It has also faced earthquakes in the past as well. In June 2022, more than 1,000 people were killed when an earthquake of magnitude 6.1 struck Khost and Patika provinces. In 2015, a major earthquake that struck the country's northeast killed over 200 people in Afghanistan. A 6.1 magnitude earthquake in 2002 killed about 1,000 people in northern Afghanistan. In 1998, another earthquake and subsequent tremors in northeast Afghanistan killed as many as more than 4,000 people. So this ultimately throws up a question as to why do earthquakes occur in Afghanistan. That is because when it comes to the world, what we have is called as the plate tectonics. So we as countries as well as continents, we do not have one single plate or earth or this particular land where there is one single plate. Instead, what we have is called as lands which are divided into plates. For example, we have the Indian plate as shown in this image. Then we also have the Arabian plate, Eurasian plate, African plate. These are the major plates that we have world over. North American plate, Joandirica plate, Pacific plate, Cocos plate, Nazca plate, South American plate, Australian plate, Philippine plate, and finally what we also have is the Antarctic plate. So continents as well as countries are on these plates. What exactly happens when it comes to earthquake? What we have is plates which move against each other. Let's say for example, we have the Eurasian plate here. So the Eurasian plate is on the northern side, and then what we have is the Indian plate. So the Indian plate, as it moves up, that is as it moves to the northern side, it hits the Eurasian plate. So this hit, this puncture, this hit from the Indian plate to the Eurasian plate is what is going to cause the earthquakes. So fault lines are existing across entire Afghanistan. So what we have is the Eurasian plate. So there is a northward movement of the Indian plate, and when there is northward movement of the Indian plate, this ultimately creates the earthquake in Afghanistan. So this is the fault line that we have. So there are large number of fault lines that exist. So whenever, and do note, this particular map that is shown here is not right. This is only for the sake of image and for the explanation. This part that we have is also part of India. This is the POK. This is officially part of India, but for the sake of explanation alone, we have taken this image. But remember, this POK is officially part of India. POK is illegally occupied by Pakistan for now, but for the sake of explanation, we have taken this image. So what exactly happens here? We have the Afghanistan, which has lot of fault lines. We have the northwestern part on one side, the northeastern part on the other side. Within Afghanistan, there are fault lines that are present. So as and when you have the Indian plate which hits the Eurasian plate, that is when an earthquake triggers. So the northern movement of the Indian plate, and you see Afghanistan which is along these fault lines, and when they move the northern side, when the Indian plate hits the Eurasian plate, this creates the earthquake, and that is the primary reason we have lot number of earthquakes in Afghanistan. And now the question is, why are there more deaths in Afghanistan? We have couple of countries which are also along the Pacific Ring of Fire. So these are the Pacific Ring of Fire countries. So you have Japan there, you also have Philippines there, but those people and the number of people who pass away and the number of people who are killed by these earthquakes are comparatively less. Why is that? That is because when you consider these two regions, when you consider Japan or Philippines, their buildings are built in such a way that they are able to withstand the tectonic imbalance. They are able to have, and their buildings are built in such a way that they do not cause much harm to the people. But when it comes to Afghanistan, it is not so. That is because number of these buildings that are built is because of clay like material, or it has a lot of concrete as well, and when it falls, it ultimately leads to a lot of damages. So Japan and other countries like in South America basically have they do have more of earthquakes as well, but then when it comes to these earthquakes, they have the stability and they're able to withstand the tectonic pressure because the buildings and technology is to such a level. But when it comes to Africa, when it comes to Afghanistan, they have these countries where the kind of concrete that is used or the kind of buildings that we have is not able to withstand the tectonic pressure. They tend to build it on clay like material, timber and adobe, and whenever this falls, it causes a large scale casualties in these parts as well. And that is why large number of earthquakes, when they strike this part of Afghanistan, large number of people pass away as well. It is this that we have to understand with respect to this topic. Now let's look into the next article. This article says an opportunity to recast India's food system. The article here basically goes on to say about three important factors. One is about food security. All of us in India want food, and India as a country has to safeguard the rights of the people and provide the food security because large number, huge population have to be fed by the Indian government. So the first important parameter is the food security. The second is with respect to the farmers' income. Who are the people who produce these goods? And who are the people who give out the crops to the people of the country? It is the farmers. So the second aspect of this article is that farmers will also have to be taken care as well. What they require is the sustainable source and the profit. Only when they have the profit, they will be in that particular profession and they will be able to produce the crops as well. So the first important factor is food security. For food security, what you require is the farmers. In case they do not make the profits, they may come out of the primary sector, and ultimately this could become a cause of concern. So what we have to do is take care of the farmers. And third thing is we also have to take care of the nature as well. When we speak about farmers, yes, they are the ones who are working for us, but we also require the support of the nature. The soil is from the nature, and then the food that we have is from the nature. The rainfall is from the nature, but what we are creating is climate change manifestation which could harm the nature. So the point is that we have to provide food to the people. For that, we have to take care of the farmers. Their security is important, and at the same time we have to take care of the nature, says this article. So if food security has to be made, if food security has to be met, if sustainable farming has to be ensured, then we have to take care of the nature, is what is this article in brief gist. So in order to accommodate all these three requests for the entire country, the author brings into picture couple of recommendations. It can only be achieved sustainably if the producers producing the food make reasonable economic returns. We did check about it, that farmers will have to be given certain amounts of profit over a period of time. Only then they would be able to withstand the pressure. They would be able to take care of their livelihood. So the first important parameter is food security. If it has to be provided, farmers' economic reforms and returns have to be taken into picture, and resilience is not only from the farming community, but the natural ecosystem will require soil, water, climatic conditions that will also have to be taken. So nutritional security with the livelihood of the farmers and the environmental security will have to be taken into picture. If we look into the data, as in the National Family Health Survey 2019 and 21, 35% of the children are stunted, 57% of the women and 25% of the men are anemic. At the other end, due to imbalanced diets and sedentary lifestyles, 24% of the adult women and 23% of the adult men are now obese. India has been stepping up efforts to reduce malnutrition. So the first important factor the author speaks is in reference to the food security as well as nutrition. So this article goes on to say that we have had nutritional issues, and in order to address these nutritional issues, what we have to focus is on the organic farming. What we have to focus is on promotion of the organic food items. According to a report by Transforming Rural India Foundation, more than 68% of the marginal farmers supplement their income with their non-farm activities. Which are these non-farm activities? Let's say, for example, they are working in Manrega, or they are entering into other areas where they are working in the industrial sector as well. So when it comes to the farming, it is not a year-long business. So what they also require is other alternatives in the form of working in the manufacturing industry, or for example in the non-skilled labor like the Manrega. So this also has to be taken care by the government, and added to it, there is depleting natural resources. Changing climate are making India's food security highly vulnerable. In fact, as in 2023 soil health survey, almost half of the cultivable land in India has become deficient in organic carbon, which is essential indicator of soil health. So what we have to do is, in order to provide food and nutritional security where we already have a crunch, because we are seeing people are anemic to it, this has to be changed. So how do we change it? Ensure that the farming community is empowered, but the farming community, 68% of them are also looking into other jobs as well. And then we have the climate change crisis. In order to overcome all these issues of food security, farming security and climate change security, what we have to do is bring few changes. What are these changes? One, the author takes into picture, one is what is called as healthy and sustainable diets. We have couple of multinational cooperation companies. These multinational cooperation companies, what do? They project oats as one of the important food crops which is healthy. Similarly, as these corporations work out, we also have the indigenous food crops as well. For example, the ragi or the jowar or other millets as well. These are also healthy. So when you have these healthy optionals at the local level, why import these from some other country in the form of oats? So as much as we are promoting oats, it is not wrong, but as much as we are promoting oats and other imported food crops, why not also advertise, why not also export these food crops like the ragi, the millet, so on and so forth. So what we need to have is healthy and sustainable diets. If we are damaging our body, that is not going to serve the purpose. So we have to intake the local food items, for which what we can make use of is ambassadors, celebrities, even religious institutions as well. So public distribution system, midday meals, railways catering, urban canteens, public and institutional procurement can help improve what at least 70% of the Indians are consuming. Even religious institutions can shape food choices as well. The author also takes into example the Tirupati temple. The Tirupati temple feeds at least 70,000 people every single day, and we also have many temples also. They also provide free food to the people, the disciples and the people who come to that particular temple. So if they can be provided, they are already providing healthy food, but if more alternatives are given, so people will start adapting the same into their personal life. So awareness will have to be given. So the first point is food security, the first point is nutritional security. So the author says healthy and sustainable diet for the people, so that this anemic nature and other nutritional values which are down can be improvised over a period of time. So PDS has to be given, ambassadors will have to be roped in, religious institutions will have to be roped in, so that they are given healthy and sustainable diet. Second, in order to support farmers so that they also have a sustainable livelihood and also generate profit over a period of time, support farmers transition towards remunerative and regenerative agricultural practices, the National Mission on Natural Farming should be supported. So the natural farming, which includes organic farming, should be supported so that they would be able to generate the profits and ultimately they would be able to make the living out of it. And then we should also move from input subsidies to direct cash support to farmers per hectare of cultivation. For example, if they are provided subsidies on urea, or for example subsidies on fertilizer, this urea or fertilizers can also be exported to another country, and that is what is happening with respect to India's export to Bangladesh as well. So there is smuggling that is taking place, illegal channels where these exports taking place. But ideally, instead of providing subsidies on the fertilizers or on these products, why not give these subsidies in the form of direct transfer to the farmers. So even if these products are exported, there is no subsidy, but this is directly given to the farmers per hectare. And Agricultural Research and Extension Services should also earmark a proportion of their respective budgets to focus on sustainable agricultural practices. So a critical approach to enhance rural income is to enable more value of additional agricultural produce in the rural areas. These middlemen will also have to be eliminated as well, and various young agri-tech enterprises such as DHET, NinjaCart are enabling such farm to buyer linkages. So the middlemen will have to be eliminated completely. So from the farmer directly to the buyers, if we are able to do, then farmers will also get good profit and buyers will also generate they will have a saving, says the author. If we are able to do so, we will be able to maintain 3 steps. One is with respect to the farm, one is with respect to the agricultural security, food security for the entire country. Second is with respect to the farming community for their profits, and third is with respect to sustainable agriculture as well as the climate change. It is this that we have to understand with respect to this article. Now let's look into the next article. This article is here important from your preliminary examination point of view. The article here speaks about Ram Leela. Ram Leela literally stands for Ram's place. It is a performance of the Ramayana epic in a series of scenes that include song, narration, recital and dialogue. When is it performed? It is performed during Dussehra, during Navaratri, and it is held every year, and this is especially played in the northern part of India, especially in the state of Uttar Pradesh. The most representative Ramleelas are those of Ayodhya, Ramnagara, Benares, Vrindavan, so on and so forth. The staging of Ramayana is based on Ramcharitamanas, and this is one of the most popular storytelling forms, and this sacred text devoted to Lord Rama, the hero of Ramayana, was composed by Tulsidas. So Ramcharitamanas was written by Tulsidas, and this Ram Leela was declared by UNESCO as one of the intangible cultural heritage of humanity in 2008. Which are other Indian intangible cultural heritage of humanity which is declared by UNESCO? Please put it on the comment section. Now let's look into the next article. This article here is speaking about Theyyam. What is Theyyam? This is one of the spectacular ritual art forms. It is practiced in the state of Kerala, especially in the northern part of Kerala. Theyyam performers include the myths and stories of many gods and celestial spirits of Kerala mythology, and its performance are vigilant and committed to guarding the purity of the art. And this Theyyam is believed to have been derived from the word Theyyam, meaning God, is based on the belief that immortal spirits, so those spirits enter into the mortal bodies to perform a ritual dance in the form of Theyyam or the divine revelation. This Theyyam is performed mostly by the males except the Devara Kutu Theyyam, which is the only Theyyam ritual performed by the women. These are some of the important facts from the preliminary examination point of view. And do note, the Theyyam is performed by Pulyas, which happens to be a scheduled caste who consider goddess Chamundi as the protector of Timiripada paddy land. Now let's look into the next article. This article says Punjab Governor withholds approval for money bills. So what are the powers with respect to the governor in comparison to the president for withholding the money bills? Will he be able to withhold? This is once again important from your preliminary examination point of view. So when it comes to the money bills, the governor, after it is passed by the state legislature, is presented to the governor for his assent. So what are the provisions available for the governor? He would be able to give his assent to the bill, then the bill becomes an act. With respect to the money bill, he may withhold his assent. So can he withhold his assent when it comes to the money bill? Yes, the governor would be able to withhold his assent to the bill. The bill then ends and does not become an act. He may also reserve the bill for the consideration of the president. So with respect to the money bill, he may give his assent to the bill, he may withhold his assent, he may reserve this bill for the consideration. However, the governor cannot return a money bill for the reconsideration of the state legislature. So can the governor return a money bill? No. He can withhold his assent, but he cannot return this bill primarily because it would have happened with the consent of the governor. That happens to be the most important factor from the preliminary examination point of view. Now let's look into the next article. This article here is speaking about Mahsa Amini. Mahsa Amini has been given the European Union Human Rights Prize. Mahsa Amini, a 22-year-old Kurdish Iranian woman, died in police custody in Iran, sparking worldwide protest against the country's conservative theocracy. And as a result, in order to ensure that human rights is protected, we have this award that is being given by the European Human Rights. So the EU award, named after Soviet dissident Andrei Sakharov, was created in the year 1988 to honor individuals or groups who defend human rights and fundamental freedom. Sakharov, a Nobel Peace Prize laureate, died in the year 1989. So remember, Mahsa Amini was given the EU Human Rights Prize. It is this that we have to understand with respect to this topic. So in case you are liking these initiatives, please do like, subscribe to our YouTube channel, and also share it with your fellow aspirants as well. Thank you for watching. All the best.